Welcome back, Courtroom Nation. Today, we've got a case that's as dramatic as it is heartbreaking. On one side, we have a defendant who claims to be turning her life around, outpatient treatment, drug tests, parenting classes, even a full-time job. But on the other side, the court isn't buying excuses that easily. With probation already extended, the looming threat of 20 years in prison hangs heavy in the air. And the judge? She's not here for empty promises. Will this defendant's recent efforts be enough to convince the court she deserves another chance? Or will her past come crashing down on her? Stick around, because the twists in this case are nothing short of explosive.
All right, so we have an issue with you.
I'm sorry?
We have an issue with you. What do you think that issue is?
Well, that I have to.
Yes, why do you keep using?
Well, you see, since I've used, I have complied with everything. I joined the EC before, and which is it's been very helpful and very motivating. I have been coming out ever since, and I have joined outpatient treatment, parenting classes, and I've been having my drug tests 4 times a week. And so that's been helping me a lot with staying away from the drugs. And I also got a job too, so, and that's 12-hour shifts. So it's been helping me a lot, and it's been keeping me busy and distracted, and I've been complying with everything ever since this, which at the time I really was I think I was just depressed. And I know it's not an excuse. But like I said, ever since this has happened, and it's sad that it took so much. It's sad that it took this to happen in order for me to start getting my life on track. But I feel like I do feel like I'm in a better place now.
Did you catch that, viewers? The judge just laid down the cold, hard truth: probation isn't a free pass. If this defendant slips up again, she's staring at a 20-year sentence. That's the maximum penalty hanging over her head right now. Think about it. After working hard to prove compliance with drug testing and treatment, one misstep could undo everything. This moment right here shows the razor-thin line between freedom and incarceration. And here's my question for you. Do you believe the court should show mercy to someone trying to change their life? Or is accountability more important when past violations are on the record? Drop your thoughts in the comments below.
All right, because here's the thing. Your probation has been extended for you to get your life in order.
Yes, ma'am.
This is not on the record because this is us having a conversation, because the next step is going to be a motion to revoke is going to be filed. You understand?
Yes, ma'am.
And the range of punishment for your offense is up to 20 years. So that means that if you're revoked, that you could potentially end up going to prison for 20 years.
Yes, ma'am.
You understand?
Yes.
So we're having this conversation, so hopefully that doesn't happen.
Yes, ma'am.
So if you're drug tested today, what are the results going to be?
They're going to be clean.
All right. When's the last time you used?
I haven't in August. I think they were in August.
But you have a failure to submit. You have a failure to submit in September. September 19th, 2022, you didn't submit.
Now here's where things get complicated. The defendant claims she's been doing everything right, calling the UA line, even showing up for extra tests on her own. But the records, they tell a different story. A missed test in September. Failure to submit. And that, my friends, is the kiss of death in probation cases. Judges don't just care about effort, they care about consistency. And inconsistency screams unreliability. Viewers, do you think this was an honest mistake? Or is it a strategic excuse to cover up use? This is exactly where credibility makes or breaks the case.
Yeah.
I don't remember that. But I know as far as I'm concerned, I've been complying with and going with everything. And also let me point out with the UAs that I'm supposed to be calling the UA line every day and testing biweekly. For the last 4 weeks, I've been calling the UA. It hasn't even asked me to come in and to submit, but I have came in anyway to make sure that I get that, UA submitted, so that way I didn't have any.
All right, probation. I'm going to want a UA today from Arizola. And can you make sure that for the UA hotline, she needs to at least be testing weekly at some time during that time when she calls in. So she's calling the UA hotline every day. So she needs to be testing at least once a week.
Yes, sure.
And tell them to continue to monitor. And I'm going to want field visits for her at least once a week. And are you still doing outpatient treatment with Victoria Spicer or no?
No, ma'am. My probation officer just enrolled me with the outpatient that they have down on Tool Semi-Canal.
And are you still residing with your mom?
Yes.
All right, so I'm going to want field visits once per month. I'm going to want a UA today. And I want the UA hotline continued. And she's to call daily. And there needs to be a UA at least once per week. And we're going to do that for 2 months and see where we are with the once per week. And then if there are no positives, then we can taper it off to maybe once every 2 weeks.
Okay.
And then we'll do that for a length of time. And then we will go forward maybe once every 3 weeks for a UA. But I know that she expires, I think, in 2023.
This is a pivotal turning point. The judge is crystal clear. Negative tests mean progress, positive tests mean prison. It's essentially a prove it or lose it situation. What stands out here is the balance. On one hand, the court is giving her a roadmap to redemption, consistent weekly tests, field visits, outpatient treatment. On the other, the sword of justice is dangling overhead, up to 20 years behind bars if she fails. This is the raw tension of probation hearings, second chances wrapped tightly in strict accountability. And the big question: can she hold it together long enough to earn her freedom?
Yes, Your Honor.
So whether or not you expire in 2023 is completely up to you. If I end up getting positive UAs from you, we'll see. Either you could end up going to prison for up to 20 years, or either your probation could be extended. So you want to be off probation, you got to do better. You understand?
Yes, Judge.
Is there anything else?
Your Honor, I did look up in the system. The last 3 UAs have come up negative.
Okay.
There is a pending result for the 12th, so we're just waiting on results for that one. Do you want the UA in court, or do you want her to be sent?
Well, she's here. We can do it here.
Okay. And then one of the issues on the well, not an issue, but with the on the supplemental report, what the officer was requesting is for you to look at the terms of her GPS device.
Mhm.
I believe she had it the amount of time that was mandated, and they were asking for removal, but you wanted to talk to her first.
Yes. So what we're going to do is I will consider removal of your GPS device in 1 month. If there are no violations on the GPS, if there's no violations with you taking your UAs, and if the UAs are negative, then I will remove the device in 1 month.
Yes, ma'am.
So whether or not that device gets removed is going to be completely up to you and your actions. You understand? Okay.
Thank
All right. Good luck to you. I'm glad you are getting help.
Thank you.
All right. 2016 CR 5076, State versus Eleanor Arizola. Can I have parties announced?
Rick Pena for the state of Texas. John Pettis for defense.
And are you Miss Arizola?
Yes.
All right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Eleanor Arizola who was placed on deferred adjudication in 2016 CR 5076 for the offense of burglary of a habitation on August the 22nd, 2017 for a period of 3 years and extended for a total of 6 years? Is that you?
Yes.
And just like that, the stakes explode. By pleading true to the violation, the defendant is basically admitting, yes, I failed my condition of probation. That one word, true, hands the court the power to revoke her supervision entirely and impose prison time. What's even more dramatic is that the prosecution agrees probation isn't working, and now the push is for time behind bars. Notice how quickly the tone shifts from warnings and conditions to sentencing and punishment. Viewers, would you have pled true here and hoped for leniency, or fought harder to dispute the violation? This is courtroom strategy in action.
State.
Yes, Your Honor, we're here this morning on state's motion indication of guilt and revoke community supervision. Violation of condition number 46. On or about the 7th day of August, 2025, in Bexar County, Texas, the defendant, Eleanor Arzola, did then and there fail to comply with biweekly urinalysis on IVR line in violation of condition number 46.
How do you plead to that, true or not true?
The state will waive the other violation.
Any objections?
No objection, Judge.
Did you understand by pleading true to violation of condition number 46, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes,
Knowing that, do you still wish to plead true to violation of condition 46?
yes,
Court will find violation of condition number 46 true. Is there a proposed agreement?
There is, Judge.
And what is the request?
Their agreement is to revoke her probation, adjudicate her guilty, sentence her to 2 years TDC.
All right, has she done anything on probation? Other than just being on probation?
She went to my office with that. She's completed that as an intervention. She's completed a significant amount, Judge. Addiction just got hold.
Probation?
Things that, she had been selling drug court for a little while.
Mm-hmm.
Did complete 123 days in my office. She did a outpatient program as well, BIPP, or parenting class. Oh, I'm sorry, the BIPP, it says there was a violation of program or services, but the my office complete, there's some classes for complete. It was on the GPS for a while. That needs to be complete as well. Total credit of $129 for her assessed fees of $5,154.
All right. The court is going to grant the motion. The court will sentence you to 4 years in the prison, give you credit for any time served, credit for any time served and successful completion of inpatient treatment. So if she was placed in the facilities and she successfully completed those, she'll have credit for those. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
yes. Oh, yes,
All right. Because I found you guilty and because I've revoked your deferred adjudication, you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Do you understand? And I'm going to also request a therapeutic community for you. I can request it for you, but you're going to have to request it as well because I do not have the authority to force them to place you in that program. Once you're released from the prison, if you can't find a sober support house or anything of that nature, just let me know and come back here and I'll pick up the phone and call someone to see if we can get you help. All right?
thank you.
All right.
Maybe.
Yes.
So let's recap this roller coaster of a case. Despite her efforts, outpatient treatment, negative drug tests, and parenting classes, the court couldn't ignore the probation violations. The final outcome: 4 years in prison. The defendant will get credit for time served and treatment completed, but the message is loud and clear: probation is a privilege, not a guarantee. This case highlights the brutal balance courts must strike between rehabilitation and accountability. And now, we want to hear from you. Do you think the sentence was fair, or should the judge have given her one more chance? Drop your take in the comments. And if you found this breakdown as gripping as we did, don't forget to smash that like button, share this video with a friend, and hit subscribe for more jaw-dropping courtroom breakdowns every week. Until next time, stay tuned, stay sharp, and stay engaged.